much. And can I just say I'm absolutely terrified of that role in reviewing consent policy in light of the Assisted Decision Making Capacity Act. It's going to be a stinker of a job. So after Peter's, I agree with absolutely everything which Peter has said about the challenges which we face in trying to give effect to this piece of legislation. I'm going to focus today on the policy and principles, where this came from, and attempt, I suppose, to identify why it matters and what we can aim for. And there will be a lot of stumbling blocks. Everything Peter says is true. I think we will have our own set of sort of added stumbling blocks. I have very serious concerns about resourcing. I have very serious concerns about not just training, but thinking and understanding what's happening and how we're going to get access to what's happening on the ground. So there are a lot of things which are scary about the legislation and giving effect to it. But there are also, and is also, a lot of potential in the legislation. So I want to talk a little bit around the potential, where it's coming from, but I will be sounding some notes of concern, some notes of caution. So in terms of what I'm doing, I'm going to very, very quickly sort of remind you of the traditional principles, which are partly being put aside by the legislation, partly rather than wholly. Why those don't work, and I'm not going to talk about that for long, because I think most of us agree they don't work. I'm going to talk about human rights, and I'm going to talk particularly, though relatively briefly, about the Convention on the Rights of the Persons with Disabilities. It's the United Nations Convention. And how that has influenced aspects of the legislation. And I'm going to ask the question as to whether, as the government seems to think, we will comply with the CRPD, we won't. Whether that's a problem or not is another question. I'm then going to talk very briefly about how we went through the process of getting to where we are in terms of legislating for capacity. Then I'm going to talk about capacity and how we decide whether someone has capacity or not. And finally, I'm going to work through the guiding principles and make a couple of general points, both as regards the potential of the guiding principles, but also, as you'll see, there's an awful lot of them. And when you have an awful lot of possible principles, some will bubble up to the surface and become the important principles, and others will bubble under the surface. And I want to talk a little bit about that and the ones that I think I'd like to see bubbling up to the surface. Okay, very quickly, traditional approach. Peter talked about it as the concertina effect. Notion, capacity, you started asking about capacity if somebody was doing something that seemed off, didn't seem quite right. So you determine capacity on the basis of their the person's outcome, the outcome of their decisions. Status, and Peter was really, really interesting to hear Peter talking about the fact that when you get a dementia diagnosis, you're immediately into a particular status, and that hasn't gone away. So that notion that your status determined your capacity. So if you had dementia, if you had an intellectual disability, you lacked, if you'd been admitted to a psychiatric hospital, compulsorily admitted, you lacked capacity. End of story. So no sort of engagement with the actual reality of the person, but engagement with who or what they diagnostic box they ticked. Best interests, and I'm going to talk a bit about best interests in various contexts throughout this brief presentation. And then my little apple there is intended to describe that neat division of the world into two parts, people who had capacity and people who don't. And there's a nice neat line between them, and we can operate on the basis of that. So that's kind of your traditional approach. Aspects of that are coming under challenge in our new legislation, but one of the points from what Peter has said is they're coming under challenge, but they're pretty embedded, and a lot of them aren't really going to go away anytime soon. In terms of making decisions, so when you fell on one side of the apple, the bit of the apple that made you lack capacity or was determined to lack capacity, decisions typically were made by objective evaluation. If there were big decisions, you had the court involved. Very little in Ireland. We've had almost extraordinarily little involved, unless the person has been made a ward of court. And of our people with who have capacity difficulties, a relatively small proportion would have been made of wards of court, and the reason for that, of course, is it costs money, and usually it happens in the context of where there are issues around assets. But if decisions weren't being made by the court, they were typically, once you're into any kind of big-ish decision, being made by experts. Families decided best interests. Main point, I suppose, in the traditional approach is the individual really didn't figure at all. They just simply didn't have a role. They weren't seen to have a role. Okay, really since 80s, early 90s, that view started to be challenged in a range of different ways. One thing is people started to look at this whole capacity, non-capacity issue and say, well, hang on, it's not that straightforward. People can have capacity to do some things and not to do others. This seems so glaringly obvious to us with our 2016 hats on, but actually if you work back not that far, that was actually new data, new information. People sort of started thinking, hang on a minute, we're actually looking at a human being here who has views and who has preferences, and who actually knows what they're doing in a lot of situations. And of course we also saw scandals and we also saw abuses, and we continue to see scandals and abuses, and notwithstanding the Mental Capacity Act in the England and Wales, they get their scandals and abuses and they're unlikely to go away anytime soon. The other issue, of course, and this is sort of, I suppose, our big legal issue, is this issue of human rights. Human rights became much more significant within this whole area. If you go back to the case law from the 80s, you're really not seeing rights mentioned at all, and then suddenly you're starting to see human rights discourse, for good or ill, coming in. From a human rights perspective, and from the point of view of where our legislation is coming from, the big human rights instrument is the Convention on the Rights of Persons with Disabilities. Came into force in 2008, and as you'll see there, it's a widely ratified convention. And it's a significant convention, and it offers an extraordinary amount of positive things. And sadly, I don't have the time to work through it at the moment. We've signed it and we're committed to ratifying it. And just, Siobhan will laugh at me explaining this because it's, but just to explain the difference between signatures and ratification. Signs mean we think this is a good thing generally, we like it, it's all right. Ratified means we'll be bound by it. Okay, so once we ratify, it becomes a much more serious. And in a minute, I'm going to show you our roadmap to ratification. So we're planning to ratify. It's government policy, it's going to happen. Well, if we had a government. When we get government, it's government policy, and we'll talk about when that happens as well in a bit. Sorry. So now I suppose the bit of the CRPD, the bit of the convention that's of particular relevance to what we're talking about today is Article 12. And this has proved to be one of the most controversial and interesting articles in the convention. I'm not going to talk about it for very long, except to say there, as you'll see, Article 12, subsection 2 talks about states parties being obliged, that's us once we ratify, to recognise that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. What does that mean? And there is a debate around what that means. Does legal capacity mean capacity for rights? In other words, we have to respect the rights of people with disabilities on an equal basis with others. What does equal mean? Or does it mean, so that's pretty uncontroversial. I don't think it's particularly challenging to say we should respect the rights of people with disabilities, and you shouldn't be discriminated against on the basis of your disability. That seems sort of straightforward. But what happens around people who have capacity impairments? Does that mean when we think about capacity and when we think about this right to legal capacity, can we ever interfere with the decision of someone with a capacity impairment? If they have an equal right to capacity as everybody else, is there any scope or any justification for interference? And I'm going to come back to that issue in a little bit. Article 12.4, you're not going to get to read it, but the slides will be available, I think, subsequently. The bit I wanted to draw, first of all, you see there's a lot of words there. In other words, there's quite a complex provision in Article 12.4, which talks about safeguards, and also talks, and I've bolded it there, the rights, will and preferences of the person, and that as the determining feature. And I'm going to come back to that because that's going to be something you're going to see in our legislation. So I just really wanted to show you this to draw attention to where that part of our legislation is coming from. What does Article 12 mean? Well, we could be here for a week talking about that. I think we had controversy last night over the common law. We'd really have controversy over this one. What does Article 12 mean? Well, the Committee on the Rights of Persons with Disabilities produced a general comment, and again, apologies to Siobhan for explaining. A general comment is basically a statement by the implementing body. Siobhan would explain this much better than me. The implementing body basically saying this is our view of what the provision means. It's not legally binding as such, but it sets out the standard that Frances Fitzgerald or her successor will be probably held to, presuming the committee continues to hold that view, will probably be held to when they have that meeting in Geneva. You know, that one where there's a little bit of coverage on the news and we sort of say, oh, that's what they said. It's obviously also a something which NGOs, local organisations within the member states can use to put pressure on states to change their laws. So a couple of kind of very striking aspects of the committee's general comment views on Article 12. First one, they don't think we should be dividing according to capacity at all. So no distinction on the basis of capacity. Second of all, they don't like the best interest principle. They say that paradigm of best interest should be replaced by a will and preferences paradigm. Now, what does that mean? What's a paradigm of best interest and what's a will and preferences paradigm? Does that mean absolute respect for will and preferences all the time? And if you don't distinguish on the basis of capacity, how do you distinguish, or do you distinguish? So a lot of quite challenging issues being raised there. I'm drawing it to your attention, not as it happens, I have some difficulties with aspects of the general comment. I'm drawing it to your attention because, as you're going to see in a minute, if you use that standard to judge the Assisted Decision Making Capacity Act, we're not complying with Article 12. Whether that's a good thing or a bad thing, that's the way it is as a measure. Now, I'm also going to talk about a couple of other issues there. Okay, so here we have the two women who were, I suppose, responsible for bringing through at that last minute. And it really was, we were into dying days of the, I can't even remember which Dáil it was now, back in the day, but it was the last Dáil. It was the, coming towards the end of 2015. Legislation was signed by the President on the 30th of December. But look how old, long before there was a CRPD, although of course negotiations had started, but back in 2003 we started trying to deal with this. So it took us, 12 years to get to a point of having a piece of legislation. When is it going to commence? That's an interesting question. In my opinion, they'll be doing incredibly well if it commences this year. There's an awful lot of work to be done. There's a terrifying amount of work to be done to make any sort of deliverable package around the legislation. I really hope they will manage to. I really hope, who do I mean by they? I'll talk about that in a second. Okay, so I will honestly. So I want to talk just briefly about how all of this fits into that broader CRPD ratification package, which, as I say, the government has committed itself to. You'll see I've done, it's a roadmap, and the reason it's a roadmap is because we published in 2015, I think it was October, our roadmap to ratification, the things we have to do to ratify the CRPD. But you'll see I went for a curly, kind of windy sign, because there's a fair amount of wiggles ahead. Other legislative changes on top of the Act we're talking primarily about today, our Mental Health Act has to be reformed. So there is a requirement, and this is an acknowledged requirement, that the Mental Health Act has to be reformed. Our Sexual Offences Bill, we have a profoundly discriminatory approach on sexual offences in relation to people with capacity impairments. It's really not good. That has to be changed, acknowledged within the roadmap. And then this lovely piece of legislation, I really don't envy who's trying to draft this one, the Equality Disability Miscellaneous Provisions Bill. And that's going to be our dolls, our equivalent of dolls. And in case you're wondering, we tried with the 2015 Act to do deprivation of liberty in it. It was there in the early days, and it just got too complicated. So they took it out. They, in this case, meaning the Department of Justice. It's a funny old bill, by the way, the assisted decision-making bill, in the sense it comes out of justice, but with bits out of health. So it's a kind of a cross-departmental piece of legislation, which presents, I think, its own challenges as well. But anyway, that Equality Disability Miscellaneous Provisions Bill is going to be how we are going to try to deal with that time bomb issue. And everything Peter says about the dolls would put the fear of God into you. It really, really would. I think it is better that we've left it to try to figure it. But that time bomb issue, because of course deprivation of liberty issues don't just arise, for example, in admitting people to psychiatric hospitals, which is what HL, the case Peter referred to, dealt with. They actually apply to nursing homes. And as you've said, has been decided in England and Wales, do they apply to people in their own homes? So there's a big job of work to come there, and I'm not sure. The other thing to draw to your attention is we're proposing to issue 2 declarations. Now, a declaration basically allows a state to say, this is what we interpret the provision to mean. We're interpreting Article 12 to say we can have substituted decision making. So in other words, we can sometimes have someone make decisions for a person. And we're interpreting Article 14, which is the one about deprivation of liberty. We're saying we can still deprive people of their liberty on the basis of the psychiatric illness and dangerousness in that context. So that's just letting you know what's coming. Okay, briefly, fear's complicated. I've been working with this for a long time. I find it really, really complicated, which links to Peter's point. What's it going to be like for people who actually have to work with this on the ground, who it's not their hobby. Loads and loads and loads of regulations and codes of practice promised. And the National Disability Authority is the body that's going to be developing them. That's relatively recent, they've been given that authority. Nomenclature of best interest is gone. And some people go, oh gosh, best interest is gone. Actually, it's not really. And I'm going to take you through that. And then lots of supported decision-making mechanisms introduced. And I know that these will be dealt with. Okay, determining capacity. Nothing particularly, very similar. So, okay, we kept capacity and we do it more or less like we always did. Functional test, abilities based, and then you've got a few additional protections. So functional, it's a specific assessment when the decision has to be made. Does the person understand the nature and consequences of the decision in the context of, back to Peter's point, the available choices? So it's only what you got. You don't get a right to anything, it's all in the context of what you've got. What are the abilities? They're identical, well, more or less identical to the abilities in the Mental Capacity Act in England and Wales. So all the issues Peter raised are our issues too. So can you understand the information? Can you retain it long enough to make a voluntary choice? That's a little bit of an addition. To use and weigh it, and can you communicate it? I'm going to come back to an issue around that communicate in a minute because it's kind of interesting. Okay, information. This is good. You're entitled to information. And you're entitled, just think of any of us if somebody talked to us in legalese or in medicalese. we wouldn't understand most of what they said. You have an entitlement to information and you're entitled to it in a way appropriate to your circumstances. Thank you. What are the changes from the common law? Couple of things. Many of you will be familiar with Fitzpatrick and Kay. The reason I've got my Coke and tomatoes is, of course, the woman in that case argued that her anemia could be treated with Coke and tomatoes, and she was found to lack capacity. And that's where the capacity test is set out. One really interesting thing is Fitzpatrick and Kay, you had a linkage. Ms. Justice Lafoy said you need to have more capacity if you're making a decision which puts your life at risk. And she said that's because of the constitutional right to life. There's nothing about that in the legislation, so does that continue to be the case? And then there are a number of other issues. Ms. Justice Lafoy talked about a requirement to believe information, but that's gone. We now just simply have this ability to use and weigh, and we could talk for hours about what all of those bits mean and how they're actually going to pan out. There are additional protections. John Lithgow there is wearing a belt and braces, in case you're wondering why I decided a picture of John Lithgow would be a good idea. Fact someone can only retain for a short period does not prevent them from being regarded as having capacity. Fact they lack capacity on a particular matter does not prevent them from having capacity at another time. All the issues Peter talked about, they're underscored in the legislation. It doesn't add anything, but it's just a sort of an additional protection. Okay, when do we need to assess capacity? And that's the humdinger of a question. Are we going to move to a world where we spend all our time assessing capacity? Because as Peter said, that's the world. If you look at the legislation, if you have a functional approach, you should be assessing capacity all the time, everywhere. Which wouldn't be very efficient. So in terms of your statutory requirement, this is when you need to assess capacity. When you're entering into or varying a co-decision-making agreement, when you're reviewing the capacity of a ward of court, and I know Áine is going to talk about this, you have an entitlement to a review after 3 years, and when you're creating an EPA. They're the only times the statute says you have to assess capacity. The much more interesting, and that's not too many, the much more interesting question is how many times beyond that will capacity have to be assessed? I'm going to be looking to the regulations and the codes for some formally assessed. I mean here, of course you should be assessing capacity all the time, but formally assessed with all the costs and all the stuff that goes with that. So let's watch out for the regulations and codes on that one. A new concept, which I'm not going to talk about for long really, it's this notion you see a concept of capacity being in question or may shortly be in question. What on earth does that mean? You need, that's what you need before you make an assisted decision making. But you assess it yourself. So I could presumably decide my capacity is in question and would shortly be in question today and go and make a decision. But it's an odd, so it's slightly odd terminology. Okay, quickly to talk about the guiding principles. Okay, these underpin the Act. They apply to all interventions, and as Peter said, we talk about relevant persons rather than P. And that's a person whose capacity is in question or someone who lacks capacity. And it covers all interveners. Which led me to wonder who is an intervener, i.e. who are bound by these principles. Susan will be bound by them, the Circuit or High Court, any courts. Any of our people who are there to assist in decision making, co-decision makers, Director of Decision Support Services, if a special visitor or general visitor is appointed, and healthcare professionals. But as far as I can figure, and this was also the subject of some heated discussion at the table last night, as far as I can figure, that's it. So they're not made generally applicable to the world at large, but to interveners. What difference does that make? I quite frankly don't know. Okay, wide range of principles. Why Groucho Marx? I'm actually making a serious point. There's a lot of them. So some will bubble up and become important, and others will sort of squish down. Because you can't give effect to, I can't remember, are you looking at about 10 principles at the same time? Because they're not going to all talk to each other in the same way. So this, I think, is very significant. Okay, I'm going to zip through these. You can get the slides if you want to, but you have a presumption of capacity, nothing terribly exciting there. Requirement for support. Delivered would be a very, very good thing. You have to support people. Incidentally, all of these Peter will be incredibly familiar with because they're pretty much all borrowed from the Mental Capacity Act in England and Wales. Unwise decisions. You can't question someone's capacity merely because they're making an unwise decision. You see the merely there? Once you have any other excuse to go in there, you can go in, but not direct copy. Fortunately, they don't do plagiarism around statutes, because if they did, we'd be in trouble. No intervention unless it's necessary, having regard to the individual. So what's necessary? How do you decide what's necessary? You're getting a feel for, what I'm trying to communicate is a feel for the looseness of the language, the point which Peter made earlier about flexibility of language and what that means. Least restrictive alternative, any intervention must minimise the risk, the restriction on the person's actions. All their rights, lots and lots of rights, which is great. I'm not in any way suggesting one should not be respecting rights, but I'm saying that you've got a lot of rights: dignity, bodily integrity, privacy, autonomy, control over financial affairs and property. But they're all going to talk to each other in different ways. They don't all lead to a nice, neat answer. And it's this flexibility point again. Proportionate interventions. Limited duration, as short a time as possible. Okay, obligations in making the intervention. You'll wonder why I have a welcome back and I have a picture of the Mental Capacity Act. We don't use the term best interests. We took the best interests standard and test from the Mental Capacity Act and we put it into the principles. It's exactly the same. So we don't use the term, but we're using all the concepts of best interests from the Mental Capacity. Now, I actually quite like best interests on the Mental Capacity Act, so I've a lot of time for that. But I am just saying, when you say, oh my goodness, best interests is gone, actually what we've done is we've just taken it and gotten rid of the name. So the intervener must be encouraged to participate. Peter talked a little bit about how that was actually working in practice. We talk, and this is exactly the same except for one change from the Mental Capacity Act. In the Mental Capacity Act in England and Wales, they talk about wishes and feelings. We talk about will and preference. It's the more modern language, but I think they're getting at the same thing. There's a load of case law in England and Wales on wishes and feelings and how you actually give it effect in practice, how you actually deal with it. Some of it is super, and the one I really like, and this woman is called Manuela Sykes, and Mr. Justice Eldergill, who was a speaker here last year, and is a special judge in the Court of Protection, issued a really, really, I think, nuanced and careful judgment where he tried to come to grips with actually giving effect to Manuela Sykes. This was her when she was a lovely young woman. She now has dementia and she wanted to live in her own home. And it was risky. And should she or shouldn't she? And he produced a really, really interesting judgment where he tried to tease out the ways to let her live in her own home for as long as she could, acknowledging that sometime her will and preference or her wishes and feelings would not be met. Sometimes she'd have to go into a nursing home. It wouldn't be possible. But he tried to give her the best go he could. And I'd like to see that becoming a bit of on the training manuals for all our interveners. Beliefs and values, you have to take account the person's beliefs and values. But again, I presume you're getting the picture. There's a whole mush of stuff in here. Consultation, you have to consult with people who will have the views of the individual, etc. Good faith and benefit. Why have I got my Shakespearean quote? The intervener must, in making an intervention, must act at all times in good faith and for the benefit of the relevant person. Best interest, basically. They don't use the word, they use the concept. The act, I should say. And then this lovely catch-all, which I think Peter referred to as well, whatever you're having yourself. All other circumstances of which the intervener is aware. So there's a lot of. So basically, I have worked through this, but basically my point is a fairly simple one, which is there are loads and loads of principles. They can't all be given effect at the same time. Some will bubble up, some will not. It's important that the right ones bubble up. Views of others. Some other people's views can be taken into account. Someone caring for the person, someone with a bona fide interest. Have to wait and see if the person can recover. You wait and see, can they recover? There are all sorts of interesting, and this is different, and doesn't seem to be something that's done in the Mental Capacity Act at all. Lots of limits on the information an intervener can obtain. And I was talking to Patricia Ricker-Clark about why is that there, and she talked about the fact that they'd seen quite a lot of cases. Many of you will know Patricia Ricker-Clark, who is, of course, has been a very significant driving force behind the legislation, and she talked about the fact that they'd seen quite a number of cases where interveners, so in other words, someone making a decision for someone, was getting at loads more information about them than they actually needed to make the decision, or to make the decision with the person. They were getting all sorts of information. So that's an odd one that's been put in. At least I think it's odd. Not odd, just interesting. But that's it. And then the very final point I want to make. Okay, loads of principles. How are they actually going to get given effect in practice? What's actually going to happen? And here, and relating back to something Peter said, as you know, most of our decisions, the vast majority of our decisions, are going to take place at circuit court level. You're really only going to be going to the High Court on appeal, or to the High Court in the case of, there are a couple of very limited circumstances in which you go to the High Court. Now the problem is, busy circuit court judges don't typically do written reports of judgments which are available to assess and analyse. This was a problem with the Court of Protection initially, which formally was, a lot of the cases were happening in camera, and that was a problem. It's not that our circuit courts will be operating in camera, it's that the actual findings will be very, very hard to get at. So it's going to be really challenging to figure out how these principles are actually being applied in practice, which is just the judicial arm of it. We'd say if you take your healthcare professionals, how are we going to actually know which principles are bubbling up and which aren't? Now, obviously there are issues of audit, there are issues of, and everything Peter said suggests we're not really going to know very much about how this piece of legislation actually works, except for academics. Aren't we marvellous? But that's basically the only way I can see that, because there's nothing in the legislation at the moment to really give us that picture. I'd really like to see something being written in to a code of practice or a regulatory standard which would give us access, even in terms of representing your clients as mental health lawyers, knowing what's actually happening on the ground, a way to get at that, I would see as a huge issue. Okay, thank you very much. I hope I did go over, but